Chris Opfer for Bloomberg Law here at the Littler Executive Employer Conference. I'm joined at the news desk today by Rob Friedman, who's a shareholder in with the firm. Rob, you're here to talk about arbitration, and the timing is very unique.
There's a lot to talk about.
Starting with a huge Supreme Court case that has to do with whether or not businesses can force their workers to sign class action waivers as part of arbitration agreements. Can you tell us a little bit about what's going on with that case, where it stands?
Sure, Chris. So there are three cases pending before the Supreme Court: Epic Systems, Morris, and Murphy Oil. And those cases will decide whether or not employers can move forward to continue to enforce class action waivers for employers. This is a really big issue for employers, and it's going to affect the enforceability of class action waivers and potentially millions of arbitration agreements around the United States.
So we could be actually getting a decision any day or week now.
Any day. In fact, we thought it could even come out today, but it'll come out by June 25th, which appears to be the final date that the Supreme Court will issue opinions.
Care to make a guess about which way they're going to come out on this thing?
Yeah, and it's the same guess I've been making for a while. We keep hoping the opinion will come out, but I think it'll be a 5-4 decision against the NLRB position. So I am inclined to believe that the Supreme Court will uphold the validity of class action waivers in employment.
So if you're a worker, I can see why you would want to be able to have a class action. If you make $10 an hour, it's expensive to hire your own lawyer and to litigate these things. Maybe they can't hire the same big firms like a Littler or something like that. Why shouldn't they be able to have class actions?
Well, class actions are disruptive, and actually, Chris, what we've found, and we've looked at this very carefully, oftentimes employees are really not the ones interested in the class action. It oftentimes will not affect their individual relief. It's something that plaintiffs' attorneys are very fond of, because it enables them to aggregate claims together in a class procedure. But as far as employees, the existence of a class or not a class ultimately does not impact their recovery. So the answer is class actions and arbitration in particular are not particularly well suited. The Supreme Court has held in the Concepcion decision, it came out in 2011, that class actions are not well suited for arbitration. The risks are too high and the appellate standard doesn't work. So as far as the existence of arbitration agreements, part of that is to make the process easier and smoother, and there's nothing about a class action that's easy or smooth. It takes a long time, it delays the process. So individual arbitration, bilateral arbitration, is what Congress envisioned when it passed the Federal Arbitration Act.
And so what's the next step here? If it goes the way that you think it will and the class action waivers are upheld, what's the impact? Will businesses change the way they operate?
I don't know if they're going to change the way they operate, in the sense that back in 2011, the Concepcion decision upheld the validity of class action waivers. So for a period of time between Concepcion and the time that the NLRB started with its attack on class action waivers, many businesses already implemented class action waivers. It's very unusual nowadays to find an arbitration agreement that does not already have a class action waiver. The impact will be, we'll likely see an increase in arbitration agreements. There's also a lot of cases that have been stayed in the courts around the country pending this decision, so those will be resolved. So I think to some degree, this restores the status quo that existed right after Concepcion, assuming the court rules the way I expect them and hope they will.
And if it goes the other way, what's the impact there?
That could have a very, very dramatic change, because businesses are expecting and have historically, since Concepcion and even before that, enforced class action waivers. That's going to take a lot of processing for businesses to understand how this is going to impact them, and it likely will affect their ability to stop class actions out of the gate. So we have to see what the opinion says. It could go a win for employers, a loss for employers, or something in between, but certainly a loss for employers, and businesses would be something that businesses would not like to see.
And one option, of course, would be class arbitration. Not everyone's on board with that. What do you make of that as an option?
Yeah, class arbitration is not a good option. And going back to the Concepcion decision, Justice Scalia enumerated good reasons why arbitration is not well suited for class proceedings. And arbitration is supposed to be simple. The risks increase dramatically to employers. blackmail type of settlements, and because of the appellate standard in arbitration is less than in the courts, class arbitration is not something that most of us who practice in this area believe is beneficial.
Well, we'll definitely be looking to see what happens with the Supreme Court this summer. Thanks.
Sounds
for joining
great.
us.
Thank you very much.